Hi, my name is Robert Shelley with Shelley Law, and my law firm assists dental practices with drafting independent contractor agreements for dental associates. Today, I'm going to talk about kind of how to create a strong independent contractor agreement that will protect the practice. So, the first thing that needs to be discussed is whether you can actually classify the dental associate as an independent contractor. The IRS lists a 20-factor test that kind of outlines what would make someone an employee versus an independent contractor. A number of those factors would be how much control you have over them. So do you determine their exact schedule and who they see and when they see them? And then how do you pay them? Do you offer benefits? Are they allowed to work elsewhere? All of those factors will go into whether the practice is actually misclassifying them or not. I find many practices want to classify them as an independent contractor to get out of paying for employment taxes or offering benefits. So you got to be pretty careful in determining which way to classify them. So I think the biggest factor that goes into the classification is probably how you pay them. If you're paying a dental associate on a straight base salary, but you're classifying them as an independent contractor, it doesn't make a lot of sense to me. So, many dental associates are paid daily rates. That would certainly make sense because there wouldn't be any paid time off, and you're just paying them for the time they're there, not other time. Or you could even do an hourly rate, or you could do net collections as well, would make sense. So they would get a percentage of whatever the practice collects on their behalf. If you're going to do a kind of net collections based compensation model, somewhere between 20 to 35% would be a reasonable amount. It varies. I mean, closer to 20 would probably make more sense for a practice, but honestly, it depends upon kind of how efficient the practice is, how many other providers they have, what's the overhead. I mean, you really need to sit down and do a pretty strong financial analysis of the situation to determine how much, the percentage that you're going to provide to the dental associate. Next would be restrictive covenants. So non-competes, non-solicits. Just because it's an independent contractor agreement doesn't necessarily mean that you can't put restrictive covenants in it. In fact, as a dental practice owner, it would be silly not to put a non-compete or a non-solicit into the agreement, unless you're in one of the states where they're completely prohibited. You're going to have to check with your state, since this is kind of for any dental practice owners. There are a handful of states where they're completely unenforceable, so check into that first. Now, as far as the non-compete, non-solicit goes, obviously the non-compete just limits the dental associate from practicing for a period of time within a limited geographic section. Somewhere between 5 to 10 miles would be a reasonable amount in most states. And then the non-solicit would stop the employee or the dental associate from soliciting patients or employees to move with them after they left the practice. So you want to make sure you have a strong restrictive covenants in there as well. Next would be kind of benefits / malpractice insurance. As an independent contractor, you should not be giving benefits. So that's health, vision, dental, life, disability, retirement, medical or dental license, DEA registration. The provider should be the one that pays for all of those things as an independent contractor. Malpractice insurance, that's kind of the one thing that I do see some practices pay for no matter whether they're an employee or independent contractor. But once again, if you want to think about the different factors, that should be something that the independent contractor probably covers as well. And then the last thing I'm going to talk about is notice. So kind of the whole point of an independent contractor agreement is it's kind of an easy in, easy out relationship. There shouldn't be a ton of strings attached, getting in or getting out. But as a healthcare provider, there has to be some kind of notice requirement. or at least there should be some kind of notice requirement in the contract, and that goes for both sides. So there should be some kind of without cause termination where either party can terminate the agreement at any time for any reason with a certain amount of notice to the other party. Most healthcare contracts are somewhere between 60 to 90 days. I think 30 days for an independent contractor agreement would be a reasonable amount. That'd be the minimum amount. For continuity of care purposes, you don't want to have like a 1 day or you can terminate them at any time. That could be a disaster for a practice if you have a full schedule of patients for weeks out for a provider and they are allowed to walk in and just say, I quit, I'm leaving. That can be a huge problem for any kind of dental practice. So I think at least 30 days, leaning probably more towards 60 or 90 would make more sense for a practice owner. Anyway, that's a brief kind of rundown of what needs to go into a independent contractor agreement for a dental associate. If you are a practice owner and would like to talk about drafting one of those, feel free to contact my law firm at the contact info listed below in the description. If you have any comments or questions, leave them in the comments and I'll answer all of them. So appreciate you watching the video. Take care.